but also with both counsel. Mr. Witness, what is the provision of the master deed for the columns condominium units with respect to the transfer of ownership?
For that, Your Honor, I don't have an idea.
You don't know when ownership is transferred?
For the ownership, ma'am, I don't have an idea. But for the acceptance of unit, yes, Your Honor.
All right. What is the provision of the master deed on the acceptance of unit?
Once the unit owner accept the unit, Your Honor, that's the only time that we will charge the association dues.
Under the language of the master deed, what is the meaning of accept? Do you have any idea?
That's the time, Your Honor, that the unit owner really accepted the unit.
Think again. What do you mean by accept? He accepts it verbally? He accepts it physically? He accepts it in writing? What is the meaning of accept?
Based on my observation, Your Honor.
Your observation?
Yes, Your Honor, that there is a form on there, but that is already for the developer side, Your Honor.
Obviously, you're not very familiar with the legal aspects of the transfer of ownership over the condominium unit.
Yes, Your Honor.
Yes. Now, our issue here is, when should the condominium unit in the columns have been declared in the SALN of the defendant? That is our issue here. To be able to answer that issue, we have to know, when did he become the owner? Now, there are two contending sides and they have different positions. According to the prosecution, the defendant became owner when the certificate of title was issued to him. At that point, apparently, your corporation took the position that the unit was deemed accepted. Is that the language you use?
For the corporation, Your Honor, when I present the master release, it was stated that August 2009, Your Honor, that the unit accepted.
Is deemed accepted when the transfer certificate of title is transferred to the buyer. Is that your practice there in your corporation?
It was accepted, Your Honor. Accepted.
Toto, there are so many methods of acceptance in law. So, what I'm saying is, under your master deed, apparently your corporation has laid down the rule that once the transfer certificate of title has been issued to the owner and accepted by him, then he's deemed to have accepted the condominium unit. You don't need to, that is not a question, but that is apparently the position of your corporation. But on the other hand, the position of the defense is that ownership was not transferred upon acceptance of the transfer certificate of title, but was transferred only when the buyer took full possession. So there are two contradictory views of when ownership was transferred, and therefore also two contradictory views on when the property should have been declared in the SALN. What year? Transfer of title was made in 2004, but apparently declaration was made only in 2009. That is our issue today. Now, I'm going to raise this question with the prosecuting counsel. Counsel, in view of this issue, I will quote to you a decision of the Philippine Supreme Court in Cebu, Winland v. Ong Xiao, which was promulgated in 2009. In effect, in this case, the Supreme Court held that symbolic or presumptive delivery, which seems to have taken place and which seems to be the anchor for the argumentation of the prosecution. Apparently, just to summarize, prosecution takes the position that once transfer certificate of title was accepted by the buyer, that was presumptive or that was symbolic delivery. And since delivery has already been accomplished, then he was the owner as of that date. That is your position. Isn't that so?
Yes, Your Honor. And that
yes.
is also provided for in the contract to sell, Your Honor,
All
of
right.
the particular unit.
Okay. But in the case of Cebu Winland, which was promulgated in 2009 by the Supreme Court, the court held that symbolic or presumptive delivery by the execution of public instrument, meaning to say the transfer certificate of title. And here I will emphasize what the court said, can be negated by the failure of the vendee to take actual possession of the land sold. What do you say, counsel?
Your Honor, we have cited,
in this case?
we have submitted to the court a memorandum regarding this issue, and we also cited, Your Honor, the case of Marcela versus Court of Appeals.
What case was that? When was that case promulgated?
It was decided, Your Honor, in March 27 and 2007.
That was 2007. This is
Yes, Your
2009.
And the facts of the case, Your Honor.
No, excuse me. Let's stay with this particular point. You are citing to the court a 2007 case. The court is citing to you a 2009 case and is asking you to comment on this provision from the Supreme Court case. We are familiar with the rule that the latest case controls.
We have also cited a 2010 decision, Your Honor.
All right. What case was that?
In the case of Raimundo S. De Leon versus Benita T. Ong, Supreme Court said, Your Honor, that under Article 1498 of the Civil Code, the execution of a notarized deed of sale is equivalent to the delivery of the thing sold.
Ah, that is a general rule, isn't
Yes,
that so? So you're just citing a general rule. Here in Winland, Supreme Court is citing a specific rule, and you know that specific prevails over general. Now, you're citing this 2010 case. Let me ask you this question. Did it involve a condominium unit? If you are not sure, you may say so.
I am not sure, Your Honor.
All right. Now, in this Cebu Winland, on which I rely very strongly because it is the latest case, I have to quote extensively from the Supreme Court. I'm quoting now. Article 1497 of the Civil Code contemplates what is known as real or actual delivery when the thing is sold in the control and possession of the vendee. On the other hand, Article 1498 refers to symbolic delivery by the execution of a public instrument. It should be noted, however, that Article 1498 does not say that the execution of the deed provides a conclusive presumption of the delivery of possession. It confines itself to providing that the execution is equivalent to delivery, which means that the presumption can be rebutted by means of clear and convincing evidence. Now, my question to you is, since there is no conclusive presumption, you're only relying on a preliminary presumption that can be overturned by clear and convincing evidence. Isn't that so?
Yes, Your Honor.
Yes, that is your position. I don't think I have... well, let me just ask, for asking sake, the defense counsel. Counsel, what is your position? Did Chief Justice actually accept the unit?
Your Honor, may I draw your attention to paragraph 7.2 of the contract to sell. Specifically, the second half of the paragraph, I will dispense with reading the first part, but the second half which says, if rectifications or adjustments are made in the unit, the seller shall, upon completion of such works, notify the purchaser of the readiness of the unit for final inspection, and the purchaser shall have 15 calendar days from receipt of such notice of final inspection to inspect the unit together with the seller for the purpose of determining whether the necessary rectifications or adjustments requested by the purchaser in connection with the first inspection have been made. In other words, Your Honor, there is a process by which acceptance must be conducted. If there are issues raised, there is a process of consultation and verification in terms of the works being done, in terms of the gripes of the purchaser, before the acceptance is made. Now, we are all familiar with the concept of a deemed acceptance. But when we speak of a deemed acceptance, that is merely a declaration of the seller. It is not perforce a voluntary recognition of the buyer that the unit has been received in good order. That is the issue in this case, Your Honor.
You're raising the argument that the phrase deemed acceptance is unilateral on the part of the condominium seller.
Precisely, Your
Understand
Honor,
that?
because a deemed acceptance indicates that there has been no acceptance by the buyer.
Counsel for the prosecution?
Your Honor, our answer to that is the applicable rule, Your Honor, is 7.3 of the contract to sell, which came later than 7.2, which is read by esteemed counsel of the defense, Your Honor. And if I may be allowed, Your Honor, 7.3 states the seller shall be deemed to have delivered the unit and the purchaser shall be deemed to have accepted the unit upon the earlier in any of the following dates, Your Honor. And there are three. The date of final inspection, or if the purchaser fails to inspect the unit within 15 calendar days from receipt of the final notice of inspection. Letter B, the date of possession by the purchaser of the unit. Letter C, the date of execution by the purchaser of the acceptance form. And letter D, and this is where we are relying, Your Honor, is the date of execution of the deed of absolute sale. So when the deed of absolute sale was executed, Your Honor, the prosecution is of the position that delivery was made. And in the case that I cited, Your Honor, a while ago in Marcella versus Court of Appeals, Supreme Court said that it is of no legal consequence that petitioner did not take actual possession or occupation of the disputed property after the execution of the deed of sale in her favor because she was already able to perfect and complete her ownership of and title over the subject property. So that is the prosecution's position, Your Honor, that upon execution of the deed of absolute sale, possession was transferred, and according to the Supreme Court, Your Honor, in Marcella versus Court of Appeals, it is of no legal consequence that the petitioner did not take actual possession. And that is our position also in this case, Your Honor.
Your Honor, just very briefly, if I may. I filed a memorandum on February 15th regarding the transfer of ownership, and we cited precisely Cebu Winland, where the Supreme Court held that symbolic delivery by the execution of a public instrument can be negated by the failure of the vendee to take actual possession. Now, good counsel has cited the execution of the absolute deed of sale, and that would have been sometime in 2004. It was, however, at that time, Your Honor, impossible to take actual possession because, as pointed out by Senator Osmeña yesterday, they were just buying space. The condominium did not yet exist, Your Honor. It came into existence in 2006, which is the only point in time, realistically, that any intelligent acceptance of the goods can be made.
Well, gentlemen, you of course realize that the filing of the SAN is governed by the implementing rules and regulations of the Civil Service Commission. Have any of you gentlemen taken the trouble to inquire from the CSC when should ownership be transferred or deemed to have been transferred with respect to a condominium unit?
I'm afraid, Your Honor, that our inquiry into the matter is inconclusive. I am guided, however, by your statements yesterday that we should first have been motivated by honesty. As pointed out by Senator Lacson, the Chief Justice honestly declared this condominium unit in 2010 as testified by Mr. Lim after it was accepted in 2009 by Mrs. Corona. And Mr. Lim further testified that the acceptance was information given to him by the builder or the seller. So we consider that as an admission on the part of the condominium builder or seller that the transfer, the complete transfer of ownership and the free, intelligent, and voluntary acceptance of possession occurred on August 12, 2009, regardless of the provisions on deemed acceptance and the issuance of title in 2004.
Your Honor, for the part of the prosecution, our inquiry with the Civil Service Commission, they informed us, Your Honor, that the SALN form itself, as well as the provision of the Constitution, the Anti-Graft and Corrupt Practices Act, as well as Republic Act 6713, clearly states that whenever an asset, Your Honor, is acquired, it must be stated. And as duly noted by the presiding officer yesterday, Your Honor, when payments were made in 2003 and in 2004 for this particular unit, an asset should have been declared by the respondent, Your Honor, because asset it has an accepted meaning, Your Honor, and no quibbling on the meaning of asset should be debated upon, Your Honor. An asset, when you take out the cash from your pocket, then you get an asset. And this is what we are trying to point out. Acceptance of the unit, Your Honor, is of no moment because in 2003 as well as in 2004, an asset was acquired by the respondent already.
Your Honor, just very briefly, supposing the condominium had never come to be, would that 3-point-something million still be an asset? It would have become a liability.
It is, Your Honor.
If that condominium unit never came to existence and no delivery was had, it could not possibly have become an asset.
Not a liability, it would be a receivable.
Receivable.
Mr. President,
Well,
Mr. President,
Yes,
Gentlemen, may I still...
the gentleman from Cebu,
may
have
I
the
have,
floor.
no, I was just going to
Oh,
ask
I
the
thought
permission.
it was the
with
lawyer's
the
talk.
permission of the
I
gentle
can
lady
give the
from
floor to Senator
Iloilo.
Osmeña.
Thank you, Madam Senator.